You see, it says, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." I put "we the people" in red because we the people, okay, do ordain and establish. That means we created this law and we're writing it down to make it. And it's for the United States of America. It's not for we the people. We the people wrote it. We the people are over it. This is for our government to follow, not the people. This constrains our government, and that's what this preamble says. That is for the government, okay, to establish justice, ensure domestic tranquility, provide for the common defense, promote general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America, for the United States of America, not for the people. Okay? Article 1, Section 1 says, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." Basically, and I put in there, granted, see in red, by the people to the government. Okay? All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Okay? Basically, what this is saying, in a nutshell, is the word legislative powers, the creation of laws. Alright? The basic running of the government shall be placed in Congress. Okay? It doesn't say anything in here, Article 1, Section 1. It doesn't say anything in here at all about executive orders being law. It says nothing about that. Okay? Let's pay attention to that. Okay, I'm going to read a little bit of an explanation on this slide that comes from the annotated version of the Constitution that I have, okay? So bear with me because I'm not the best reader. Although some of the framers wished to limit suffrage to property owners, there was no practical way to fix one requirement that would effectively cover voters in all states or that could anticipate changes in the value of property over time. The clause thus made the basic national and state electorates identical, but states could still impose other qualifications on the right to vote for members of their upper houses or their governors. The state, no longer corresponding age requirements mentioned in the state constitutions or specified for elections to the British House of Commons. One of the first constitutional questions the House of Representatives faced in 1789 was whether William Lofton Smith, a native of South Carolina, was qualified to represent his state. Smith was studying in England when independence was declared and returned to Charleston only after the war was over. It could thus be argued, in theory, that he had not yet been a citizen of the United States for 7 years. The House rejected this challenge, holding that Smith enjoyed birthright citizenship and that his wartime residence overseas did not affect it. By rejecting language requiring residence in a state for a fixed period, the framers made newcomers to a state immediately eligible for elections. States cannot add further qualifications for eligibility, and only voters at the polls can limit the number of terms that the elected representatives and senators serves. Alright, that's been effected since 1913. just for a little clarification, okay? Alright, this is the part of Article 1, specifically Section 2, that has people's tails in a twist. And they often say that the Founding Fathers, this is what makes them racist and slave owners, and, you know, that the Constitution itself is racist. And this is what they often bring to bear for that argument. But the book I'm taking this out of, this annotated version of the Constitution, here's the explanation for this, okay? It says, the precise meaning of direct taxes, quote unquote, was uncertain. When Rufus King asked the fellow framers for a definition, Madison recorded that, quote, no one answered, unquote. Poll taxes levied on individuals are the clearest example of direct taxes. A flat tax on acreage would be another. In 1796, the Supreme Court addressed the issue in the contrived case of Hilton versus United States, the first occasion on which it subjected an act of Congress to constitutional review while upholding a tax on carriages. A century later, in the equally contrived case of Pollock versus Farmers Loan and Trust, 1895, the court struck down a federal income tax as a direct tax requiring apportionment, again that word, apportionment, among the states. The question was finally settled by the 16th Amendment, which I don't think is legal. It passed in the dead of night. There were not enough votes. There's a whole controversy over the 16th Amendment and whether it's actually law. We'll go over that in another video. The 3/5 rule originated in a proposed 1783 amendment to the Articles of Confederation that would have apportioned the common expenses of the Union among the states by population. The use of the phrase all other persons, quote unquote, as a euphemism for slaves illustrates the framers' moral embarrassment over having to use the Constitution to recognize slavery as a legal established institution. Okay? They were embarrassed because the southern states would not sign on to the Constitution because they would have been outnumbered by the number of slaves there for voting reasons. So, in order to get the Constitution passed, what they did was they reached basically a compromise with the southern states that wouldn't give the slaves a full vote, all right, which would really increase their representation and then increase the number of representatives in the House based on the slavery issue. So the compromise was to make them 3/5 of a person. They didn't like it, but the good outweighed the bad in this case and in this scenario, and that's what we were left with. And it doesn't mean they were racist. It just meant that they were trying to do the right thing by all people, and they were being blocked by the southern slave states. And they did their best to overcome that, to get this document passed so that everybody could benefit, okay? Concern about the mounting difficulty of collecting census data has sparked controversy over whether actual enumeration, quote unquote, precludes using statistical sampling procedures that might obtain more accurate results than head-by-head counting. Opponents argued that the framers insisted on accurate head counts to avoid possible corruption or improper influence in the distribution of seats. Proponents respond that head counts are more likely to produce errors or omissions in that significantly disadvantaged urban populations and racial and ethical boundaries and minorities. The minimal size of a House district was reduced from 40,000 to 30,000 on the very last day of the convention, and only then with an unprecedented direct endorsement from George Washington. Speaking from the chair, who rightly foresaw that many Americans would be disturbed by the large number of constituents each member of the House would represent. No constitutional requirement limits the size of the House to 435 representatives, as set in 1911, which makes it a smaller body than the British House of Commons. Unhappiness with the rough estimates used to set the initial allocation of seats helped to convince the framers that a regular census was necessary. Southern delegates wrongly expected future censuses to reveal that their expanding region would move closer to population parity with the North. Impeachment is only a power to charge an official with misconduct, and the House thus acts as the equivalent of a grand jury. In 17th century England, impeachment was used as a highly politicized weapon in the recurring struggles between the House of Commons and the Stuart crown. As a hereditary monarch, the king could not be impeached and removed from office. Instead, one would either have to charge him with high treason, as when the Puritan revolutionaries tried to execute Charles I in 1649, or rebel against his rule, as happened with James II in 1688. But a monarch's ministers and advisors could be charged for their misdeeds, or as surrogates for grievances against the throne. The use of impeachment for the partisan purposes was abandoned in Britain after 1715, but the American colonial and state legislators had learned to use the impeachment process in a less partisan, more prudent way, and the framers drew on their experience then.